We're really excited to have you all here, and I think we'll go ahead and get started. But first off, I'm Caroline Garvey. I'm your Sustainability Club President, and we're super excited to host a speaker as a part of our speaker series. Today, we have Thomas Linzey, who is an environmental lawyer, and his presentation is called Who Speaks for the Trees? The Movements for the Rights of Nature. He's going to be talking about the growing rights of nature movement, in which the national, state, and local governments have adopted laws, recognized enforceable rights for rivers, bays, different natural features. And I think without further ado, though, I will go ahead and hand it over to Thomas and let him get started.
Great. Thanks, Carolyn. And just a big thank you to Carolyn and the group for hosting this event today. I did a talk in California earlier today. So by the glory of Zoom, we're able to get around quite a bit and give talks. So at the outset, I just wanted to talk about what we're going to talk about, which is that what we're talking about today is about recognizing human civil rights protections for nature. So it kind of makes our brains bend the wrong way sometimes when we hear that, I think, but we know all about human civil rights. So like First Amendment right to free speech and freedom of religion and Second Amendment rights to bear arms. And essentially in US society, as with most other countries, we recognize the highest values that we have by recognizing them as rights. So the values that most of us can agree upon, we tend to codify those values into this language of rights. So again, right to free speech, right to bear arms, right to religious freedom, those types of things. What we're going to be talking about today is recognizing those human civil rights type protections for nature and ecosystems. As Carolyn mentioned, think rivers and mountains and forests and what some people would refer to as natural features like bays and lagoons and even the ocean itself as having certain rights. Now, we wouldn't be talking about this if our existing system of environmental law was actually working. If our existing system of environmental law was working, we wouldn't be talking about recognizing rights for rivers and mountains and forests and all these kinds of things. The problem is, as you guys know probably better than most, is that the environmental legal system that we have in the United States isn't working. And in fact, it's failing momentously in a bunch of different areas, including climate change, deforestation, acidification of the oceans, you name it. We've got these huge problems facing us today that the environmental legal system seems to have no answers to. And no answers for to actually fix. So we're all just kind of wandering around in the wilderness at this point, hoping these problems go away, but there's very little being done to actually fix those problems. Now, of course, again, we wouldn't be here talking about rights of nature, this weird, phrase to our lips sometimes is rights of nature, unless we had been successful in making this environmental system work. And folks like me, who have been practicing environmental law for 25 years now, in the beginning, actually tried to make our existing system of environmental law work. And as folks may know, the existing system of environmental law in the country today really deals with permits. You'll have a state agency like the Ohio Environmental Agency or state agency issuing permits. If a corporation wants to put in an incinerator or a hog factory farm, or some kind of fracking operation. Ohio is pretty much ground zero for fracking and frack wastewater injection wells, all that kind of bad stuff that communities don't necessarily want. Well, what happens is the state environmental agency will accept an application from a corporation to put that particular project in. What environmental lawyers do, and what we've done for the past 40 years, is we actually take the corporation's application for a permit after the permit has been issued. So the state agency issues the permit, corporation asks for one, agency issues the permit. Environmental lawyers basically come in the bottom of the ninth inning. When the community says, we don't want this here, we don't want this toxic waste incinerator, we want this 25,000 head hog factory farm, it's not our idea of agriculture or farming in this community. And so they turn to folks like us and they say, we want to find a way to stop this thing. And again, for the past 40 years, this is what conventional environmental law has basically been, is that lawyers come in representing community organizations, and we appeal permit issuances. So state environmental agency issues it, we appeal it. And essentially during that process, which we did for about 10 years, my former organization was called the Community Environmental Legal Defense Fund, CELDEF for short. Folks may or may not have heard about it, but we were the folks that drafted the Lake Erie Bill of Rights in Toledo to protect Lake Erie. I'm now with a different organization, the Center for Democratic and Environmental Rights. We focus more on rights of nature work. But suffice it to say, for 10 years, we tried to make the existing environmental system work. We appealed these permits. And the job of an environmental lawyer, although it sounds sexy, some days maybe, is not really at all. What we do is we sit at our desk and we take the corporate permit application and we compare it against the environmental regulations that have been written within the state to control the issuance of the permit from the state. And in doing so, we try to find gaps, omissions, and deficiencies. Places where the corporation missed something that had to be included within the permit application. And we argue to a judge, Your Honor, something's missing from the permit application, the state never should have issued it, and therefore you need to overturn the permit so the community doesn't get the toxic waste incinerator, or the factory farm, or the quarry, or whatever else they're fighting from coming in. And so that meant that we were in front of judges representing community groups, about 100 community groups in rural Pennsylvania. Got my law degree in Pennsylvania. A lot of the work that has happened over the past 20 years has been in rural Pennsylvania, not Pittsburgh or Philly, but the area in between. And that's where a lot of the community groups that we represented came from, trying to stop different projects. We would end up in front of judges arguing, you know, Your Honor, under section 24, little c, little d, little I, little Roman numeral 2, little c, little I, little 2, little e, little f, that there was something missing from the permit application, like a signature, like the president hadn't signed the permit application, or there was a bond amount that hadn't been posted, or there was a study that was 10 years old and it should have been updated. Basically looking for all these things that were missing. That's the big point here. Missing from the permit application for us to argue that the judge should overturn the state's issuance of the permit. That's what environmental law has become in the United States today. And most of the time we would win in front of the judge. The judge would say, you know, you're right. Under that section, there's a signature missing, or a bond amount wasn't placed, or there was a study that wasn't updated. And the judge would overturn the permit. He would throw the permit out and say, the corporation shouldn't have gotten this permit in the first place. The state made a mistake, shouldn't have issued it, and therefore I'm overturning the permit. Well, what happened next? Well, we would go back to the house of the community group that we were representing, and we would have a victory party. You know, have some beer and some wine, and some snacks, and everybody would pat themselves on the back, and we'd say, oh, that's great. We're not going to get the toxic waste incinerator or the factory farm. We're not going to get the project that we were trying to stop. And we'd all feel really good about ourselves, and the community group would be happy, and because they found a lawyer that could speak intelligently, and the judge decided to do something that they agreed with. And everybody was happy and had this big victory party. Well, what would happen next? Well, the corporation, and we were facing off against some of the largest corporations in the US, like Waste Management Corporation and Monsanto Corporation, and Chemical Waste Management, and Chesapeake Energy, one of the largest fracking companies in the United States. We're facing off against these large companies, and they would simply come back in 20 days. And they would say, well, thank you for finding those gaps, omissions, and deficiencies in our permit application. We've now gathered the materials that we need. We signed the application, we submitted the new bond, we did the new study, and now we're coming back to ask for a new permit to be issued. Basically, thank you for finding those gaps, omissions, and deficiencies. Now we've completed our permit application, we're ready for this permit. And the community group would come back to us and they'd say, Mr. Linzey, we need you to do that jujitsu again that you did the first time around to get this permit application thrown out. And frustratingly, we would have to look back at them and we would have to say, we're sorry, there's nothing left here for us to do, because the gaps, omissions, and deficiencies that we had found in the permit application aren't there anymore. And I'm shortening the story for purposes of the talk, but some of these last 10, 15 years, we had a case with Walmart Corporation that was trying to develop a wetland, and that went on for 7 years. So corporations fill in the holes, we come back, find more holes, and then they come back and fill in the holes. It's kind of endless. It's like this hamster wheel kind of thing. Or people that have gone, folks, if you've gone to the fairs, county fairs, it's like whack-a-mole. You know, the whack-a-mole game where you hit the ball and another one pops up. And while we were busy 7 years with Walmart, Walmart was putting in 20 other stores down the road in other communities that didn't want those big box stores coming into their community either. And so it got to a point where the large law firms that were representing the corporations that we were litigating against would come up to me after the argument was over and thank us for finding the gaps, omissions, and deficiencies in the permit application, because then that law firm who was working for the corporation could charge more for more hours to fill in the holes that we had identified through the gaps, omissions, and deficiencies that we had done as part of this permit appeal process. So for about 10 years, we banged our head against that particular wall. And somebody back then taught me a lot of things that I was not smart enough to know at the time, one of which was that at least we thought that when we filed these permit appeals on behalf of these rural, mostly rural community organizations, that we were at least costing the corporations money, that they had to shell out money for their lawyers to actually defend our permit appeal against them, that they had to hire the lawyers to come in and represent the corporation. It was then that we learned that the monies that the corporations spend on their own lawyers to defend these permit issuances, permit appeals, is tax deductible under the system of law. That the corporations themselves can deduct whatever they spend on the lawyers to defend against the permit issuances that we were coming in to challenge on the permit grounds. So it was structural, that corporations, we weren't costing corporations any money in terms of these permit appeals. And then, you know, this person said something else. She said, back then when we were trying to make this environmental system work, she said that the only thing that environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists, because the regulations themselves make us predictable as to how we fight when a corporation comes in, because guess what? It's the corporate industry that writes the regulations in the first place. And so why would we think that we would be able to stop a project based on regulations or a script that was written by somebody else, that we then come in and try to make it work for ourselves? After all, if you were the Monsanto Corporation writing regulations around pesticide application in your hometown, why in the world would you write anything into the regulations to give any power whatsoever to the community in which you're trying to apply the pesticide in? No, it doesn't make any sense. You know, they say the definition of insanity is trying to do the same thing over and over and over and over again and hoping for a different result the next time. Environmental law has been this kind of giant hamster wheel under which we work under someone else's script. And then when we try to stop something, those regulations, that script, make us predictable. And it should come as no surprise at this point that things are worse now environmentally. Again, I don't need to tell you guys this, but things are worse now environmentally than they were 40 years ago before we passed the major environmental laws in the United States. The Clean Air Act and the Clean Water Act and the National Environmental Policy Act and the Endangered Species Act is acronym soup of environmental laws that we have in the United States that I personally have litigated over the past 25 years, that things are worse now than before they were passed, because we're essentially set up in this artificial system where we're trying to fight environmental change and degradation under a system of law whose rules have been written by the very people that are ostensibly supposed to be regulated by those regulations. So sometimes that comes across as cynical. I think it comes across as less cynical now, as environmental stuff, climate change, everything else is coming back to roost. But essentially, we weren't stopping, excuse my French, but we weren't stopping shit from coming in. We would, we'd have these 6, 7, 8 year battles, but eventually the toxic waste incinerator would be sited, the factory farm would come in, the frack well would operate, the frack waste would be dumped on land. Didn't matter what we were doing. But we got recognized as one of the best environmental law firms in the country. even though the record on paper that we had of these appeals was almost perfect. You know, we won 120, some of them first rounders. Eventually the project would go in, but it didn't matter because we won the first round, and on paper that made us look good. Got invited by Al Gore to the White House one year as one of the best environmental law firms in the country. Got the money, got the recognition, got the awards, got the prizes, because nobody gave a shit in the liberal progressive community, at least, that we were losing in the end, but at least we were winning in the beginning, which apparently made us a really good environmental law firm in this country. So we came to a point where we had to start to re-examine what we were doing. We kind of would rather have start working at a Kinko's or a copy place than continue to practice environmental law, because the only thing we were doing was helping corporations build better permit applications, which is in essence, again, what environmental law is today. So it made us really ask some really difficult questions about how environmental law is structured in the United States, and to a more bedrock level, how Western law. And so Western law is the law of the United States. It's European, comes over to us from England, common law, all that boring stuff. But it's a Western system of law. It's a European system of law. And the European system of law is much different than an indigenous understanding of nature. So Western system of law treats nature basically as dead, as an inanimate thing that can be used and owned. That's how the Western system of law sees nature. Nature's not alive. Nature is dead. It's here for us to use and exploit. And in fact, the assumption is we will exploit it. The best that we can do is simply regulate the rate at which we destroy it. That's what the regulatory stuff is all about, just regulating the rate at which we destroy nature. That is much different than indigenous tribal understandings of nature and ecosystems. Nature and tribal systems tend to see nature as living, ecosystems as animated. So not the dead vision that Western legal society has, but a living version under indigenous understandings. And you see this most clearly when you talk to tribes. So we represent a bunch of tribes across the United States. We work with them on a weekly, monthly basis, tribal members. I just keynoted the Tribal Environmental Law Summit two days ago, which is the big summit for tribes across the United States. So when you talk to the Ponca Nation in Oklahoma, the tribal nation, they talk about speaking for those without voices. Or the White Earth Nation, the Chippewa in Minnesota, they speak about representing the flying people and the swimming people and the singing people, meaning animals in the, salmon and birds, and they see it as animated, living systems. Or the Yurok Nation in California, Northern California, who talks about the Klamath River as being a relative, an actual living relative of theirs, and the connectedness that means that they have to the river. Contrast that with Sir Francis Bacon. Sir Francis Bacon still taught in schools today, but he was an English philosopher. And his most famous statement is that the job of Europeans or Western system of law is to torture nature on a rack to extract her secrets. To torture nature on a rack to extract her secrets. So again, the difference couldn't be any more stark between an indigenous system that talks about the flying people, swimming people, singing people, rivers as relatives and connected to everything else, versus torturing nature on a rack to extract her secrets. And in essence, that Sir Francis Bacon stuff is where our Western system of law, what it's built around. And it's that Western system of law that treats nature as property. Today, we all, not you probably, but most of us own property. So we have a deed. We have a deed to a 10-acre piece of land. Western law says you have the right to destroy that 10-acre piece of land as part of your bundle of rights that goes with that deed, with that property rights. You can destroy it. You can take the 10-acre piece of land, make it into a 10-acre airfield if you want, concrete the whole thing, and destroy all the ecosystem. It's a right of ownership that comes with that deed for your piece of property. Because we treat nature as a property right, the more nature you can own under the system of law, the more nature you can destroy. So the wealthier you are, the more land you can own, the more land you can actually destroy, the ecosystems that you can destroy. And under this Western system of law, we have a US Constitution, of course, that protects property rights and says that, there are certain things that laws can't do to your property. Well, if nature is property, then there's a limit as to how we can protect nature because property is protected within that US constitutional construct. So usually at this point in the talk, either somebody's thinking or I say it out loud, so what? So what? We have this system, right? We gotta do the best we can with it. To which, there's a guy on TV called Dr. Phil. He says, how's that working for you? Our system ain't working so well because we are where we are and we're in the worst place ever. And it seems to us that it's time to shift to something else. Well, when we were doing our exploration about the system of Western environmental law, system of Western law, and what else was possible, we ran across an article a guy wrote back in 1972, ancient history, 1972. A guy named Christopher Stone, he's a professor at the University of Southern California. Christopher Stone one day had a law school class after lunch, and everybody was falling asleep because that's what happens after lunch. Everybody was falling asleep. And Christopher Stone said, hey, I need to inject something into this talk to wake the students up. And so he asked the question, what if nature had standing? And standing is just this fancy legal word for saying access to the courts. Like when I sue someone or we sue someone or we get sued, you automatically have access to the courts if you're injured. So if you can show that you've been injured or harmed by the actions of the defendant, whoever you're suing, then you automatically get access to the courts. Nature has no standing at this point, doesn't exist in the courts because a forest, an ocean, a river, a lagoon can't bring a lawsuit. Because under the system of law, the only people that can bring lawsuits are people, persons, humans. The legal system is not open to the natural environment or ecosystem. So Christopher Stone threw this question out. He said, what if trees had standing? What if forests could go into court and actually sue against corporations or people that were trying to actually cut that forest down or damage the environment in some way? So eventually that classroom conversation was just intended to keep people awake, became a law review article called Should Trees Have Standing? Where Christopher Stone made the legal argument that nature should have standing, access to the courts to sue as a plaintiff through people standing in the shoes of those ecosystems to bring those lawsuits. And it was a perfect storm back in 1972 because there was a case called Sierra Club versus Morton, and the case name's not important, but it was a case that was reaching the United States Supreme Court. And the case dealt with a project by the Walt Disney Company to build this huge resort in Mineral King Valley. So if people know where San Francisco is in California, just drive straight east. It is now Sequoia National Park, but back then it was a huge area of land that the Walt Disney Company wanted to develop into a ski resort. And this wasn't just any ski resort. This is 1.7 million annual visitors, bigger than Disneyland. So a development bigger than Disneyland in the middle of nowhere, east of San Francisco, Sierra Nevada mountains, 20,000 skiers, huge, huge project. The Sierra Club sued to stop it. The Sierra Club sued the federal government to stop a permit from being issued to Walt Disney to put this project in. The courts threw them out of court. Said, you have no business being here. You haven't been injured by this development personally. You don't live there. You don't own property there. You haven't been physically injured or harmed by what's planned to go in there. Went up to the US Supreme Court. The US Supreme Court agreed with the lower courts and said, get out of here, Sierra Club. You are not entitled to be a plaintiff here, and we're going to dismiss you. We're going to kick you out, which is what they did. For that opinion that was written by the US Supreme Court, there was a dissenting opinion written by a justice named William O. Douglas. So Justice William Douglas, probably one of the most progressive Supreme Court justices, nature-friendly Supreme Court justices that we've ever had on the court. And in that dissenting opinion, Justice Douglas said, what if trees had standing? So he went back to Christopher Stone's piece and actually took Christopher Stone's piece and put it into the dissenting Supreme Court opinion. So a huge, huge thing, if you've ever seen Supreme Court opinions, they don't usually talk in this language, And we'll read a paragraph of what Justice Douglas wrote, because he basically embraced this concept of ecosystems having standing. And this is what he wrote. This is actually language from the dissenting opinion. He wrote, "The critical question of standing would be simplified and also put neatly in focus if we fashioned a federal rule that allowed environmental issues to be litigated before federal agencies or federal courts in the name of the inanimate object about to be despoiled, defaced, or invaded by roads and bulldozers, and where injury is the subject of public outrage. Contemporary public concern for protecting nature's ecological equilibrium," you'll never see that in the US Supreme Court case again, "should lead to the conferral of standing upon environmental objects to sue for their own preservation. This suit would therefore be more properly labeled as Mineral King versus Morton." So not Sierra Club versus Morton, but Mineral King, i.e. the area to be developed by the Walt Disney Company, versus Morton, the ecosystem as a plaintiff, harmed enough to get into court under this theory of law that was advanced by Christopher Stone, later by Justice William Douglas. So there were a bunch of, a small number of attempts to take this concept and make it into law. So in Florida, you had a case brought by key deer. So a species of deer, actually as a plaintiff, brought a suit. You had a case with loggerhead turtles, where loggerhead turtles were the plaintiff in a couple of lawsuits against mostly counties that were trying to put beach lighting in, other things that would interfere with loggerhead turtle habitat. So a couple cases where lawyers played around with this new concept on the fringe, kind of the radical fringe of what it would look like. But most of those efforts died off. And until we came around in 2006, still ancient history, but 2006, we represented a small community in Pennsylvania, northwest of Philadelphia, known as Tamaqua Borough. So a very small city, 7,000 people, big, called Tamaqua. And Tamaqua was being proposed as a dumping ground for PCB-laden dredge brought in from the Delaware River. So the thumbnail background here is that the governors of Pennsylvania and Delaware decided to dredge the Delaware River to make it deeper for boats, for commercial boats to come in. And that dredge, the muck at the bottom that they were pulling out, was full of polychlorinated biphenyls. So PCBs, one of the most dangerous, toxic, synthetic chemicals known to man, flooded through this muck at the bottom of the river. And the grand plan was to take it, haul it to Tamaqua, and dump it into old mine pits. Tamaqua is an old mining area, has a bunch of open mine pits in Tamaqua. The idea, the bright brain surgeon idea, was to take this PCB dredge, haul it to Tamaqua, dump it into the mine pits, forget about it. People of Tamaqua said, screw you. We don't want that stuff coming in. We don't want to be a toilet for Philadelphia. Why don't you dump it in suburban Philadelphia, where all the multi-million-dollar houses are, McMansions. But instead, the governor said, nope, we're coming to Tamaqua. We're going to dump it there. And the people of Tamaqua said, we're not going to accept it. We're not going to do this. And they turned to us to draft a local law, an ordinance, a local law passed by a local council, that would ban the dumping of dredge waste within the community of Tamaqua. And so we did that. We drafted it. We worked with the city council there, the borough council. They adopted it. And then they turned to us to ask us for something new, which is we had been talking with them about this concept of nature having rights and what that might mean in terms of access to the courts. And they asked us to draft something that would recognize rights for the rivers and the streams within Tamaqua. So one of those rivers, the Little Schuylkill River, supplies drinking water to the city of Philadelphia. So that's no small deal. Others, like the Wabash, Panther Creeks, basically people fished in them, recreated in them, enjoyed them, but understood that if they got polluted by this dredge, the PCB stuff coming in, that there was very, very little that they could do about it under conventional environmental law. And they wanted to create a new structure of law that would allow them to actually defend these waterways within the borough of Tamaqua. So we wrote that ordinance for them and with them, and they adopted it. They became the first government in the globe, first municipality, first place in the world to actually adopt a law recognizing the rights of ecosystems, again, civil rights type protections for ecosystems within the borough of Tamaqua, specifically the rights to exist, flourish, and naturally evolve. Those are the rights, the civil rights types of protections that were provided to waterways in Tomaco. So then things got really interesting, as if they weren't already, which is that we got a call from the country of Ecuador. So why Ecuador, you might ask? Well, Ecuador was going through a constitutional drafting process at the national level. This wasn't any podunk, little county council, town ordinance, whatever. This was the Constitutional Assembly of the country of Ecuador that was writing a new constitution, who had read about Tomaco. That's how small the world is today. They had read about what had happened in this tiny little town of 7,000 people, and they called us up to ask us if we would come down and help them write a new national constitution for the country of Ecuador that would put the rights of nature into a federal constitution, a national level constitution. So again, none of the small municipal stuff, but way up here. And so we said yes, and we went, and we met with the constitutional drafters, the assembly on a mountaintop in Ecuador, where they had sequestered them to write this new constitution. We told them the stories about what had happened in Pennsylvania around this rights of nature concept. And they asked us to help them to draft language to put into the national Ecuadorian constitution, which is what we did. And that constitution then went out for ratification to the entire public, all voters in Ecuador. It was overwhelmingly adopted by the voters of Ecuador. And Ecuador, through that process, became the first country to shift from a property-based rights-based system, property-based system of environmental protection, i.e. if you own it, you can destroy it, all the stuff we talked about before, shifting to a rights-based system of environmental protection, in which ecosystems had rights and ecosystems could actually access courts on their own. So what did that mean? Well, we sat back and watched as a bunch of lawsuits were filed. The first lawsuit that was filed was a case that's now known as Vilcabamba River versus Province of Loja. Doesn't matter what the name is, but bend your brains around this one, which is that the river was the plaintiff. The Vilcabamba River was the plaintiff in the case, suing a local government that was dumping road debris into the river, thus changing the river's course, kind of suffocating the river. And the river was suing to stop the local government from dumping road debris into the river anymore. Two people along the banks of the river had brought suit on behalf of the Vilcabamba, stepping into the shoes of the river to actually sue the local government. More amazingly, the judge ruled in favor of the river as the plaintiff. It was the first case in the world in which an ecosystem had served as a plaintiff and in which a court had ruled in favor of the river in terms of the relief that it was asking under these constitutional provisions. So again, amazing stuff. And in Ecuador, there's been about 60 enforcement cases to date. Illegal gold mining, folks may have followed some of the shark fin fishing stuff that happens off the coast of Ecuador. It's been applied against that. There are now 3 big cases in the Ecuadorian Constitutional Court in which they're being asked to rule on nature preserves, other aspects of how rights of nature stuff can be used to protect ecosystems and natural communities. So big stuff in Ecuador, and still the only country to put it into their national constitution. If we then boomerang back around to the United States, in 2010, the city of Pittsburgh was faced with a plan to frack. And for folks who may not know what fracking is, but it's this new practice of oil and gas extraction where companies put high pressure water into the ground to explode to get natural gas out of the rock formations underneath. As you do so, it sends up radioactive water and causes these explosions underground. This is the new method of exploring for natural gas. In the city of Pittsburgh, there was a plan to frack underneath Catholic cemeteries in the city. So the fracking companies had signed a contract with the Catholic cemetery associations to actually frack for natural gas underneath the Catholic cemeteries within the city. Needless to say, city council officials and other groups were not happy about having frack companies trying to exploit natural gas from underneath their grandparents who died a number of years ago and others who reside within the Catholic cemetery. So they turned to us and said, well, we want to ban fracking within the city of Pittsburgh. And we said, okay, let's draft something that bans fracking. So we did that. And then they said, hey, we've heard what happened in Ecuador. We've heard what's happened in Tamaulipas, some of these small communities in Pennsylvania. Could you actually draft something that would recognize the rights of the Ohio, Allegheny, and Monongahela rivers that flow through the city of Pittsburgh? So the three rivers, Three Rivers Stadium, Three Rivers, they all meet each other in downtown Pittsburgh. And we said, sure. So we drafted up a rights of nature law to actually protect or recognize those rivers as having rights within the city of Pittsburgh. And hold on to your hats, but the city council unanimously adopted the ordinance, both banning fracking within the city of Pittsburgh, which hadn't been done in Pennsylvania up until then, but also recognizing the rights of the three rivers, basically to be protected against frack chemicals, anything that would interfere with their rights to exist and flourish and thrive, and these other rights that were contained within that law. So to date, just kind of winding up here with the last couple of things, there are 36 communities in the United States, mostly small communities, cities, townships. There's a county in California. There was a county in New Mexico, but most of these are relatively small cities, townships, and boroughs that have passed these rights of nature laws in the U.S. In Pennsylvania, we've had two ecosystems, a watershed and a creek, which have actually made motions to intervene in federal court as parties. Haven't been too successful, but there have been those actions taken to try to shove ecosystems that have been protected with rights into litigation in those federal courts. And as you guys might know, the Lake Erie Bill of Rights passed 62% by the people in the city of Toledo to recognize Lake Erie as having certain rights within the city and its watershed outside of city limits. A lot of people heard about that. It was on the nightly talk shows with CNN, MSNBC, basically brought the concept higher up the ladder. And then something, at least to me, still, a lot of us pushing boulders up the hill, some stuff started getting easier, which is in 2016, without any legislation whatsoever, no laws passed, no national constitutional stuff, no legislative framework, the Colombian Constitutional Court ruled in 2016 that the Rio Trato River, which is one of the major river waterways in Colombia, had rights. So they weren't working from a law, nothing had been passed, but judges stepped out and said, look, this is happening in Ecuador, it's happening in Bolivia, it's happening in a bunch of other places internationally. We think it's the new emerging international norm of environmental protection. And we're going to adopt it here, even without a law. We're going to say it's jurisprudence, it's precedent. We're going to rule it as a court ruling, put it in a decree. We're going to create those rights by judge-made law, kind of thing. In 2017, an Indian court in India ruled that the Ganges River, Ganges, huge river, cultural significance in India, was actually a legal person with rights, certain rights as well. Again, ruling that it's an emerging international norm of environmental law because these various places have been passing it. Colombian Supreme Court, again in 2018, ruled that the Amazon was the subject of rights. The Amazon River Basin, subject of rights, had rights, these civil rights type protections for ecosystems. And in 2019, Bangladesh, the high court, highest court in the land, ruled that all rivers in the country have rights that must be protected against those activities that would violate those rights. And in Uganda, just last year, they passed a National Environmental Act which recognized rights for all ecosystems in Uganda. So that was huge as well. Different part of the globe, but same concept, rights for ecosystems. And finally, we talked at the beginning about tribes, but indigenous communities, indigenous nations in the US and abroad have begun to pick up this concept. So the Ho-Chunk tribe in 2015, which is in Wisconsin, became the first to vote on a constitutional provision in the tribal constitution. So just like the United States has a US Constitution and Ohio has an Ohio Constitution, tribes, because they're sovereign nations for some purposes of the law, also have their own constitution, their tribal constitution. In 2015, the Ho-Chunk tribe took a first vote to actually amend their tribal constitution with a rights of nature law. So that was the first tribe to attempt to do something. The Ponca were next in Oklahoma to pass a rights of nature law to protect against fracking. The Ojibwe, the White Earth Nation, Winona LaDuke is a well-known person from the White Earth Nation in Minnesota. they passed a rights of nature law to protect wild rice, known as monomen in their language, but to protect wild rice and wild rice habitat there, which is a cultural staple of the tribe. And finally, the Menominee in Wisconsin adopted rights of nature to protect the Menominee River, which is the main waterway in Wisconsin. The Yurok tribe in Northern California recognized the Klamath River as having rights in Northern California. And finally, most recently, only a couple weeks ago, the Nez Perce tribe in Idaho recognized the rights of the Snake River in that state. So they were the latest one, most recent one to do something like that. And I'll finish up just with a, kind of an election relevant thing here, which is we think that the most important environmental ballot initiative on the ballot this November is appearing in Orange County, Florida. For folks that don't know Florida that well, Orange County is Orlando. So Orlando area, 1.4 million people in this county, 30th largest county in the United States, has placed on the ballot an initiative to recognize rights for the Wekiva, Econ-Lahatchie River, and all waterways within Orange County. And I don't know whether folks have been following what's happening in Florida, but they're having a water crisis there. So between the red tide, these red blooms, algae blooms that are happening off the coast, which is killing off all the sea life off the coast. Even before COVID, people walking on the beaches there were wearing full masks because of the cyanotoxins that are coming out of the algae. In Biscayne Bay, so we're talking southeastern part of Florida, just last week and a half ago, Biscayne Bay dropped to 0 dissolved oxygen levels, which means incapable of sustaining life because there's no dissolved oxygen in the water. So there was a huge die-off in Biscayne Bay. And they were using backhoes and backloaders to actually load dead sea life on a lot of these beaches. So they're hauling away manatees and dolphins and all this dead sea life that has come about as a result of this huge scale water crisis pollution that's happening in Florida. As a result of that, a group in Orange County began working with the county to actually put an initiative onto the ballot for a popular vote this November. And so on November 3rd, people of Orange County are going to be voting to adopt, hopefully, this rights of waterways law that's on the ballot. It will be the biggest municipality in the United States to adopt a rights of waterways law to try to turn back the tide of what's happening there from this water crisis pollution stuff that's happening. I personally think it's the most important ballot initiative this year on the ballot anywhere in the US, this November 3rd initiative in Orange County. So a lot's happening. There's always places that are thinking about moving stuff, adopting stuff. Ohio has been a hotbed, believe it or not, of some rights of nature laws and other community rights laws where communities are trying to protect their environment at the local level. The basic theory is here, just to end on this, which is that what we're talking about is municipalities, local governments, and communities passing heightened environmental standards. The heightened environmental standards come in the form of this rights of nature stuff, which has these 3 components: recognition of rights. 2, they outline who can represent those ecosystems in court. And 3rd, remedies about what restoration looks like for the ecosystems that are damaged. And frankly, I think after doing this work for 25 years, that this is the next frontier of environmental law. And that eventually this will be the default, just like chasing permits and playing whack-a-mole and doing the stuff with permit issuances now is how we treat environmental law, that this rights of nature stuff is the next frontier. So if any of you are going to law school, in a very short amount of time, this is going to become the most sexiest thing to learn in law school in terms of this emerging frontier of environmental law and practicing this new stuff, which I think is probably one of our best chances of not killing ourselves in the process and not killing the planet. So that's it. Thank you.
Thank you so much. It's really hard to get applause over Zoom, but I'm sure everyone also like my enthusiasm. Did you still have time for any questions if there were questions?
Yeah, I have about 15 minutes or so. So if folks have questions, I'm happy to stick around and answer them.
All right, well, um, if anyone had any questions, they can go ahead. There's no like formal way to do this over Zoom. Just unmute yourself. Um, if not, I had one question that I was going to ask. I was just curious. I've always been interested in how Indigenous cultures have viewed like their relationship with the land and other living aspects of our environment. I was just wondering if you know there's been any cases of like Indigenous consulting on environmental law, because I know they've always been at the forefront of activism and like protesting, but I didn't know if there was any real legal consulting in that area.
Yeah, so it's a good question. There's been very little. And usually when the word consultation is used within federal law, like it says, you know, if you're going to put this pipeline through, and pipelines have been a big issue for Indigenous communities, as you guys probably know, that there's always the word consultation built in, that the federal agency has to consult with the tribe. The problem with the word consult is that it doesn't carry the power to veto it. So if a tribe says no to something like a pipeline running that's going to have impacts on the reservation or on the tribe itself, that all the agency is required to do is simply ask the opinion of the tribe. But the tribe doesn't have legal veto power or legally binding power to say no. That's unlike a lot of other countries where indigenous people, like in Ecuador or Colombia or Bolivia, the word consult actually means legally binding power. So they have to get the agreement of the tribe to actually do those projects. Here in the US, it's not the case, unfortunately. But also it's a weakened, you know, it's a point that it shares with things like the National Environmental Policy Act in the United States. We have something that requires environmental impact statements to be done for projects that get federal money. So if you want to put in a pipeline, you're getting federal money, you have to do this environmental impact statement. I was dumb enough in law school to think that an environmental impact statement meant you had to choose the most environmentally sound alternative after you did the study. So when you do the study, it's a, you know, okay, we can run the pipeline these 4 different ways, or we cannot build the pipeline at all. I always thought that kind of, you know, you did the study and then you legally had to choose the least damaging alternative, but that's not the case. The environmental impact statement is just a study document. As long as you do it and you check the box, the agency is free to make any decision that they want. Doesn't matter what the environmental impact statement says. So that was kind of a disillusionment both with the environmental impact statement process, but also with the tribe's consultation requirement, because we always thought consultation meant actual consultation, which meant getting agreement of some kind, but it doesn't. It basically just means we write a letter, we check the box, and if the tribe doesn't reply or whatever the tribe says, doesn't matter. We can still pick what we want to pick.
Thank you. That answers that.
I have a question. Sorry. So I interned at the federal government level doing environmental law this summer, and I saw a lot of what you were talking about with like the limitations of regulations and such. And so I guess what like benefits have you seen doing this at the state level? And then like, do you have hope for like a more federal level policy initiative with these kinds of things?
Yeah, it's a great question. I think we're at the beginning of the beginning, which is good news because we used to be at the beginning of the beginning of the beginning. But it used to be when you talk about rights of nature, people would laugh you out of the room. Like I did a law school tour back in, 2002 or something. And we had people walking out. We had law professors walking out of the room because it was just rights of nature was too crazy to even think about. Today, because of what's happened internationally as well as in the US with the passage of these laws, it's become less of a radical fringe. It's moving kind of in the mainstream. I mean, for God's sake, the Florida Democratic Party endorsed the Orange County Initiative on the Rights of Waterways in Orange County, Florida the other day. That never would have happened before. And the Democratic National Committee in 2016 put a rights of nature plank into the national platform for the Democratic Party of the United States. So it slowly began to move its way in. On the state level, we have 5 states which have proposed laws which would recognize the authority of municipalities, cities, towns, and counties to pass rights of nature laws. Right now, it's kind of a gray area. You know, can municipalities pass these? Can they not? They haven't really been given the power to do so by the state. This is an attempt to carve out space as those municipalities have to pass the laws. And then at the federal level, to draft a federal amendment that would actually recognize nature in the federal. Of course, that's a long way away, many years away, but is something on the blotter that people are thinking about. Is, you know, if Ecuador did it, why doesn't the U.S. do it? Why doesn't somebody propose that rights of nature be driven into the U.S. Constitution? So I think the drafting part is easy. Getting back to your precise question, the drafting part is easy. We know what goes in it. We know what the language is. But it's the political mechanics, the apparatus that actually has to move. And that's a cultural thing. Our brains have to switch gears. And I think it's like before about the Democratic Party gaining some kind of and stuff less crazy. We had the drafter of one of the primary drafters of the Clean Water. So this thing that's held out as the best of the best, the Clean Water Act in the US. He's a professor at Tulane Law School. He came out last year in favor of rights of nature. We did a conference with him at Tulane in New Orleans on the rights of nature. And the University of Florida Law School has done a rights of nature conference now. And the University of Vermont Law School, which is a big environmental law leader, has done a rights of nature conference. So I think slowly this is gaining credence, especially with the international development starting to gain some speed. I think we're a long way from states taking that kind of action. I think we're a long way from the federal government taking it. There's a grass revolt. These that are big brunt of the are finally standing up and do this work. And we're going to try to build enough pressure, which is in the US. You know, the abolitionists. It took the suffragists 140 years to win the right to vote, kind of organized suffrage. And abolitionists, it took 20 years just to get the 13th Amendment. But anyway, it takes a long time to do this stuff. I think we're finally on the ramp where it's become a solid theory. It's less crazy on its way towards working its way into real law in the United States. But I tend to think of stuff as what kind of power and pressure can emerge from the bunch of stuff.
Thank you.
Burning questions.
I also had a question. So kind of like what you talked about, how we have the most policies in place right now, yet our environment is at its worst. So I know you kind of talked about how like we need to implement the whole rights of nature thing, but what other reasons do you think that's our situation right now?
Yeah, so I think we have this whole thing about endless economic growth being possible. I mean, it's tough to peel one thing away without running into all the rest. We have this culture where we think endless economic growth is possible, that the earth is not finite, that resources are not finite, that we can technology our way out of any problem that we have. We're basically getting to a point where we're threatening our own life support systems. So clean air, clean water, I mean, and eventually it comes to a time where it's less about nature and ecosystems and more about the fact that without healthy ecosystems, we're screwed. We're a dead race. I mean, our species is, on its way out. And I think that we're closer to that precipice now than ever. I think that the political parties pretty much, not to get political because it really isn't, but is that the only difference between the political parties is how fast and how far down the accelerator is pressed on its way to the cliff. So that, we're either pressing it really fast, economic growth, get rid of regulation, or we're pressing it slowly, but one way or the other, we're headed off the cliff. It doesn't matter which way. And so the kind of reimagining that I think it's going to take for us to understand what it means to live sustainably on the planet means changing everything about how we work, how we live. The rights of nature is just a way to get into that conversation. And because if nature has rights, you have to change all of that stuff. You have to change how you do farming. You have to change how you make clothing. You have to change how you design transportation. You have to change everything about you. And until the human race really comes to grips with the fact that we're killing ourselves off, which in, you know, blunt moments, that's how we talk, is that's the only thing powerful enough to really give birth to this structural paradigm shift that has to take place. Otherwise, we're out the door. I mean, there's not much left. And in fact, you know, when you look at the numbers, 60% of all species are gone, 90% of all forests in the United States have been chopped down. You know, we almost, I think it's 90% of the public now lives within 6 miles of a Superfund site. It's like, it's just endless. What we've done to this place is horrifying. And instead of getting sad, which you know, people get sad, it's okay to get sad, but people need to get angry. We need to change the system of law. We need to put something in place that actually works for us, because otherwise we're pretty much dead. And unfortunately, and it sucks, but we've put it on your generation now, because we have failed to do much of anything to stop what's happening, and now it's laid on your doorstep. So usually when I give talks in person, the first thing I say is I apologize for how much we screwed up the planet, but it's now on your shoulders to actually do something about it, because my generation hasn't been able to do much of anything at all. And hopefully that's changing with some of this new work, but you know, it is what it is.
Thank you.
I think that's going to be all the time we have questions for, but that's a really good stopping point, and I want to say thank you for all the work that you have done, because it's obviously made a difference, and thank you again for taking time out of your day to come talk to us. I really enjoyed learning about all of this, and just a reminder for everyone else, this has been recorded, so I will be able to send out a recording of this if you or anyone of your friends who wasn't able to make it would like to watch later. Please let them know they can do so. And I guess, would you like to talk about the link that you just sent?
Yeah, so for folks that want to learn more about what's happening, our organization is the Center for Democratic and Environmental Rights, and I put the webpage here. We have a newsletter if folks want to sign up for it. We put it out to update folks on developments. And also we're partnering with Widener Law School in Pennsylvania to do a global forum on the rights of nature coming up October 1st and 2nd, so Thursday and Friday of next week. So all the information is on our webpage. It's free, and it's two days, 4 hours each day, but we're going to be moving continent to continent, Asia, North America, but bringing in the experts from around the globe who've worked on rights of nature, and who will be, participating for an hour on each panel about talking about what's happening in their own country and how they see things rolling out. So it's intended to be a kind of, one bite takes all, this is what's happening around the globe on rights of nature. And if you're interested, you can tune in for an hour here or there or for the whole thing, but information about the event is up on our webpage.
Thank you so much again, Thomas, and everyone else, have a good night. Thank you for coming, and I hope to see some of you at the meeting on Wednesday. But other than that, that is all we have, I think. Yes, all right. Then have a good night, everyone.
Thank you, everybody.